Hi, I'm Miles Mason. I'm a divorce attorney and the founder of the Miles Mason Family Law Group. We represent clients in the greater Memphis, Collierville, and Germantown, Tennessee areas. This talk is about divorce and the Electronic Communications Privacy Act. I'm going to explain why recording your spouse's private conversations without permission could create serious problems. Spying on your spouse can adversely affect your divorce and cause avoidable complications. The first question is, why would someone feel compelled to spy on their spouse? Adultery. Often one of the spouses suspects the other of cheating, but there may be other suspicions of wrongdoing. Excessive gambling, illegal drug use, for example. Eventually the focus shifts to proving marital fault to obtain the divorce. Proving the case in court requires evidence. To substantiate the alleged grounds for divorce in the complaint, many people will snoop, spy, eavesdrop, engage in surveillance, or record their spouse's private conversations with other people. That's a big mistake. At best, it's a misguided attempt to gather evidence for the divorce. At worst, it's a federal crime. Here's the rationale for spying in a typical situation. I can record my spouse's private calls and catch him or her in the act. The recording will prove he or she is a dirty, rotten scoundrel. It's very tempting, isn't it? Just tape the cheating phone calls to the paramour. Just print some of those emails between your spouse and the boyfriend or girlfriend. That's concrete evidence of adultery. In Tennessee law, adultery is grounds for divorce. Slam dunk, right? Wrong. Recording your spouse's private conversations can violate the Electronic Communications Privacy Act, also known as the ECPA. That's federal law. Violating the ECPA can result in substantial criminal penalties and civil damages. The difficulties you may experience in the divorce, they'll pale in comparison to the problems you'll encounter if prosecuted or sued for wiretapping and electronic surveillance. What is the ECPA? When you talk to a lawyer about recording your spouse's private telephone conversations, or if you suspect you're the one being spied on, the discussion will inevitably turn to the ECPA. The ECPA is amended, and its predecessor, the Stored Wire and Electronic Communications Act, are federal laws prohibiting electronic spying in certain circumstances, even between spouses. An illegally recorded phone call between your spouse and someone else can be held inadmissible in court. Here's the basic rule. Use of illegally obtained communications as evidence in Tennessee court is prohibited if that disclosure would violate the ECPA. See 18 U.S.C. section 2515. In other words, the recording of a private communication, the meeting, the phone call, the email, the voicemail, without consent could be excluded as admissible evidence in the court. In the divorce case, sure, there's always a few exceptions, and that's why you need to discuss this with your lawyer. So what acts are illegal under the ECPA? These are the four main points you need to understand about the ECPA and its scope. The unintentional authorized use, the intentional unauthorized use or attempted use of a mechanical or other device to intercept, use, or disclose your spouse's wire, electronic, or oral communication violates the ECPA. For example, using your recorder to tape your spouse's telephone call or face-to-face meeting when you have no authorization to do so. Okay. Next, the intentional unauthorized access of your spouse's stored wired or electronic communication violates the ECPA as well. For example, accessing your spouse's private email account without authorization. For there to be an ECPA violation, you must have justifiable expectation of privacy in the electronic communication. Let me give you an example. When your spouse posts an unrestricted Facebook message, there's no justifiable expectation of privacy. But an email message to or from a private account would raise a justifiable expectation of privacy. Here's another point. For there to be an ECPA violation, the interception or access must be unauthorized or conducted without your spouse's consent. The scope of that consent is important. For example, if your spouse gave you the username and password to his or her private Amazon account so you could stream movies, nothing else, then consent is arguably limited to that use only. You may not have access to the rest of the Amazon account manager or review your spouse's past and present purchases to see if there were gifts to a secret lover. Okay? Obviously, there's a lot of different permutations and scenarios that you got to consider. Only electronic communications fall under the ECPA. What then is an electronic communication? Just about any old or new technology is covered. Face-to-face conversations that have been intercepted by a mechanical device, including a drone, landline, telephone calls, voice over internet protocol or VoIP, email, voicemail, Vmail, pager messages, web streaming, video posted to a private account such as Match.com. That's just a small list. The last question to answer is, what are the consequences of violating the ECPA? The consequences of illegally surveilling your spouse can be quite severe. There's the possibility of actual financial damages, statutory damages, punitive damages, attorney's fees awarded to your spouse plus litigation costs, injunctive relief, which is a stop order, and if imprisonment could be an issue if convicted of certain violations. That's why I and most family lawyers strongly recommend staying away from recording your spouse's communications unless you're seeking to protect a child's safety, and then only after you've consulted with your attorney. There may be other exceptions depending on the circumstances, but the reasons must be genuine, sincere, and require a high level of need. I'm Miles Mason from the Miles Mason Family Law Group. Thanks for joining me. Check out more information on our website, memphisdivorce.com.